Can the state forcibly administer antipsychotic medication to a patient with mental illness? To find out, you have to read Rivers v. Katz, but it's 17 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I normally cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is part of a special series I'm covering on cases of interest to the elder law and estate planning community. This is a very important, it's a landmark case called Rivers v. Katz. The citation for this case is 67 New York 2nd 485, published by the New York Court of Appeals on June 10th of 1986. This is a very important case. It's been cited by 248 other cases and 358 other publications, articles, treatises. The issue in this case is whether the state can administer antipsychotic medication to a mentally ill patient who's been involuntarily confined to a state facility, to a state mental health facility. The law you have to understand to appreciate where this case fits in is just very simply New York State's Constitution and the federal Constitution both have a due process right. New York State's Constitution is found at Article 1, Section 6, and quite simply it says, no person shall be deprived of life, liberty, or property without due process of law. So what are the facts of this case? The facts are there are 3 different mentally ill individuals. There's Mark Rivers, Florence Zatz, and Florence Grassi. They're all patients, involuntary patients at the Harlem Valley Psychiatric Center, which is a state mental health hospital. And they were put there involuntarily because court orders had found them to be persons in need of involuntary care and treatment because they have mental illnesses for which care and treatment as a patient in a hospital is essential to their welfare, and their judgment is so impaired that they are unable to understand the need for such care and treatment. So they're involuntary patients at a hospital. Zatz and Rivers and Grassi, they want to give them antipsychotic medication. And antipsychotic medication has the potential for adverse side effects. All 3 of them say, I don't want antipsychotic medication. But the doctors at the hospital say, well, they follow the administrative procedures that are in place, which does not involve a court. It's just their own administrative procedures. And they say, I don't care that you don't want to. You're not competent to make medical decisions. That's why you're a patient in a mental hospital. And they give them the antipsychotic medication over their objection without further court involvement. Zatz and Rivers both sue, saying you've deprived me of my due process of law. And Grassi files an Article 78. The difference in the claims is kind of irrelevant because each of them, the court basically dismisses it and the appellate division affirms what the court does. And it goes to the Court of Appeals and they consolidate all 3 of them. And they say, they reverse it. They say, due process clause, it's sort of uncontroversial that the due process clause of the New York State Constitution affords every individual of adult years of sound mind a right to determine what shall be done with their own body and to control their own course of their own treatment. The question here and the difference that they have is that the respondents, the mental health professionals, they say, well, that applies to people with a sound mind, but these people don't have a sound mind. They've been declared and adjudicated to be mentally ill. But the Court of Appeals says that does not matter. They reverse them because they say the common law right extends equally. It extends equally to mentally ill persons who are not to be treated as people of lesser dignity or law. What's clear is that mentally competent people have the right to control the course of their treatment, and so too should mentally ill people. So the court distinguishes, and they make a point of saying that from a medical point of view, medical professionals can say or have said to them that just because you are incompetent, just because you have mental illness, does not mean that you don't have bodily autonomy and that you don't have the ability to distinguish what you should or should not be doing for your own medical care. So they say that the common law right is part of the due process right, and mentally ill people have that common law right. But they say, this is important, they say the right to reject treatment is not absolute and may yield to a compelling state interest. And they point to 2 different ways it can yield. First, in an emergency situation, they say when the patient presents a danger to himself or others, or engages in a dangerous or potentially destructive conduct in a facility, the state may, as part of its police power, its power to sort of keep the peace, administer antipsychotic medication over objection. Like emergency situations. So the hospital can, in a situation where someone's going berserk, they can do an emergency administration of medication without court involvement. Stat medication, only so long as the emergency persists. That's the emergency power. But none of these three individuals were they trying to involuntarily give antipsychotic medication because of emergencies. It was more like control, treatment of their mental illness, and that involves the court's, the state's parens patriae power, which is sort of like parens patriae is like they're the parent, like they're the caretaker of this person who's vulnerable. And in a non-emergency situation, pursuant to the parens patriae power, the state has to have a hearing to overcome someone's refusal to administer antipsychotic medication. And the state has the burden of proof of clear and convincing evidence. That's the standard. It's not beyond a reasonable doubt. It's not preponderance of evidence, not preponderance of the evidence. The standard would be by clear and convincing evidence, the state must prove two things. One, the patient lacks capacity to make a treatment decision. If the patient has capacity to make a treatment decision, the state loses. So the first thing they have to prove is that the patient lacks capacity to make a treatment decision. And then the second part of the test is having now proven that the patient has no capacity to make a treatment decision, that the state has to prove by clear and convincing evidence that the proposed treatment that the doctors want to go through is narrowly tailored to give substantial effect to the patient's liberty interest, considering all the relevant circumstances, including the patient's best interest, benefits to be gained, adverse side effects, and less intrusive alternatives. The long and the short of it is, being a mentally ill patient of a state facility is itself insufficient justification to override an individual's fundamental right to choose their own medical treatment. That by itself is insufficient. So if it's not an emergency situation and the state wants to overcome someone's refusal, they have to have a Rivers v. Katz hearing. That's in fact what it's called based on this case, a Rivers v. Katz hearing about those two issues, patient capacity and the treatment plan. And that's the case of Rivers v. Katz. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.